Go on the record in the matters 25 CF 65, 25 CF 100, 25 CF 101, 25 FO 65, 93, 174, 185, 186, 187, 188, 20, and 25 TR 2.
Right away, notice how the judge is juggling multiple cases at once. Ever wonder why defendants often face several files in the same hearing? It's because a court consolidates related matters for efficiency, but it also raises the stakes. Imagine balancing 3 legal files at once.
66, 25 FO 84. State of Wisconsin versus Austin Bearhart. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman appearing for defense with Mr. Bearhart in person. We're set today in these matters for statuses and initial appearances and an intake in 25 FO 174. Not guilty will be entered in that matter. As it relates to the other 2 cases, Mr. Chapman, were you able to go over the criminal complaints?
I was not, Judge. I still haven't seen the criminal complaints because I still haven't been appointed on them because Mr. Bearhart hasn't filled out the paperwork yet.
All right, so you're.
This is a critical moment. Without a properly assigned public defender, the defendant has no official representation on record. The law requires these procedural steps, but from a defendant's perspective, it can feel like endless red tape. Do you think this system protects fairness or just slows things down?
But you are court appointed on the other matters?
Actually, public defender appointed, I think.
Okay.
At least I didn't, yeah, public defender.
So you have to wait, Mr. Bearhart, you have to contact PD's office to have Mr. Chapman appointed to these cases, and you may need to reapply. Sometimes they don't make you do that. What would you like to do?
Judge, I'd ask that it be set for a plea and sentencing. I think whether I'm appointed or not, those new cases are going to be dismissed and read in.
October 9th at 3.
Thank you. Don't go anywhere yet. Hang out in the hallway. I want to talk to you before you leave. Okay.
So it's my understanding, I mean, we wouldn't need to even do an initial or a waiver.
Since
if they're
it's likely
DRI'd.
since it's going to be a read in, we would not need a waiver. We probably would need an initial to get the criminal complaint in front of the court.
Okay,
But
so that's what we'll do then. We'll do initial. Okay, thank you. We'll see you October 9th at 3 or at 2. When did I say 2:45?
3 o'clock, Judge.
3 o'clock. All right. Thank you. We are adjourned. You can come get your notice.
Pick that up. I'll see you right outside. Okay.
Ashley Johnson.
Here's some courtroom drama. Missing court usually spells big trouble, but Johnson got her warrant quashed after showing compliance. This shows judges can be flexible, but only if you demonstrate responsibility afterward. Have you seen cases where missing a date cost someone everything?
You can come on up. We will go on the record in the matter 24 CF 232, State of Wisconsin versus Ashley Johnson. The state appears through District Attorney Kevin Schmidt in person. Ms. Johnson appears in person with counsel Daniel Chapman. We're set here today in this matter for a status. Mr. Chapman, please update the court.
Judge, I believe this matter was scheduled after Ms. Johnson missed court and then had her warrant quashed. She has done her assessment and the matter is resolved. We just need a plea and sentencing date.
October 9th at 3:30.
Works for me. Does it work for you?
Yes.
Okay, thank you. That's a Thursday.
October 9th at 3:30. We will see you then. We are adjourned.
Please be there about a half hour early.
Mr. Oldman?
Yes, I'm going to have
Oldman?
multiple people in a row and we will have paperwork to go through.
Okay.
Thank you.
Yep.
Here, I can get you your notice.
Do you have a notice? We will go on the record in the matter 25 CM 102, State of Wisconsin versus Carl Oman. The state appears through District Attorney Kevin Schmidt in person. Mr. Oman appears in person with counsel Daniel Chapman. We're here for status. Mr. Chapman, please update the court.
Judge, this matter is not resolved, and I do not believe it's likely to. I'd ask that it be set for a plea and sentencing, or sorry, for a jury trial.
How many days?
I would think one day,
Mr.
but
Schmidt?
could be turned into a mess of conflicting testimony if it comes to that.
This is where things heat up. What started as a one-day trial just doubled. 2 full days, 8 witnesses, and conflicting testimony expected. That's how quickly a simple case can explode into a courtroom marathon.
I think one day there were a lot of people present, so that's the only thing that gives me a bit of pause. Because my witness list would be 8 people.
I'm going to rely on you and
Let's set it for 2 to be safe, Judge.
November 17 and 18.
Those work for me.
2-day jury, November 17 and 18. We do not need lab or anything of that nature. All right. Let's get a final pretrial. Can you do October 13th, anytime in the morning, or did I ask you that already?
I am available. How
You pick, you choose.
about 9 o'clock? I have to be in Hayward by 11:15.
All right, October 13 at 9. October 13 at 9 a.m. Oh, wait, do I have you? No, never mind, sorry. Okay, October 13th, 9 a.m. You can come get your notice. You're free to leave. So you understand, that would be what the court calls, it's a final pretrial, my drop dead date. An agreement must be reached by that date or it will go to trial unless the defendant pleads to all of the charges or the district attorney dismisses them, okay? So you can come get your notice and you're free to leave. Need a brief second since it's been fired.
Thank you.
We'll take a break after this next one. Ms. Andrick? Are you not doing this one, Mr. Schmidt? Andrick.
Competency. Competency review.
Yeah, it was on at 2:30, but we had to bump over it to get all the other matters done.
Competency hearings are among the toughest parts of criminal law. If a defendant isn't mentally fit to stand trial, the entire process pauses. It's not about guilt or innocence yet. It's about whether they can even understand what's happening. Should the system push forward or keep waiting? That's the heart of the dilemma here.
We will go on the record in the matter 24 CF 236, State of Wisconsin versus Andrea Andrick. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Andrick in person with counsel Daniel Chapman. We are here for a review hearing. There's been some occurrences and things happening in this case. We had a competency report done. And Mr. Chapman, do you object to that competency report and the finding?
I was unable to sufficiently discuss that finding with Ms. Andrick, so I do not take a position on it.
All right, Mr. Schmidt and Mr. Chapman, and if you're unable to do that, what do you want to do? Reset this or?
It's not a new competency finding. She's already been found not competent. This is a review. And according to the document, it doesn't look like there was much of a change in
I'm not
recommendation.
watching you, Ms. Andrick.
It doesn't look like the doctors are noting any changes in circumstances. So I think we just continue to wait until an opportunity arises for her to be returned to competence or for the 1 year to expire.
I thought that they were asking that she be brought in and regain competency at a facility. Maybe I read it wrong. Sandra, shh. Sandra, stop talking.
I only see not likely to be restored to competency. It doesn't.
This is an updated form, an updated one from something I read. Oh, there was, okay. There's that order for commitment. Then she was committed.
I'm not aware of that. Is that a separate case?
I'm a bit. Oh, wait, just.
I
wait.
just see the ma'am.
You need to stop talking or I'm going to have you out, okay?
I just see that she
Oh,
lacks
no,
substantial
it was
mental
from the
capacity.
letter. It was from July 3rd, 2025 from Melanie Leonard, DHS Forensic Mental Health Section. And then we did receive then the competency report from Kristen Jackson.
I think they were having trouble finding her at that point.
All right, so Mr. Schmidt. I don't even know where she is. I don't know what she's doing.
Well, what it indicates is she's not doing outpatient competency restoration right now because they didn't think she was appropriate, and she's on a waiting list for mental health hospital. So.
Right.
Yeah, that was my understanding. I didn't, the waiting list is the issue.
I'm in a group home, ma'am.
So,
I am in a group home.
They're not requesting a warrant or her.
Sandra, I'm gonna have you go outside, okay?
They're not requesting a warrant or for her to be taken into
No,
custody.
you're not understanding. That's
Okay.
part of the point of this hearing, but you need to stop talking
Okay,
until the
I'll
judge
shut
asks you a
up.
question.
Okay.
Thank you.
Okay.
If you cannot say any word, you can stay right there, okay? But
I'll be quiet.
no matter what happens in here, I have to understand where we are. So do the attorneys. Mr. Chapman will talk to you after and explain everything to you, okay? All right, so it's your understanding by review, they're not stating that they want to take her into custody right now, but that she's on a waiting list, and right now she'll just stay where she currently is.
They say they're not requesting it right now, but that it may be requested should difficulties arise with voluntary admission. So I think what they're saying is she's on the waiting list, and if she doesn't comply with going to mental health at that point, then they'd be asking for a warrant. That's my reading of the July 3rd letter.
All right, so right now, that's our understanding. We have no further update as to that. She's currently in a group home. I am going to tell you, Ms. Andrick, you have to comply with everything that they say, okay? If they need you to do some kind of assessments or tests, you must voluntarily and you must comply, okay? What would you like to do? Should we set this for another hearing? Should we kind of let it go?
Judge, to be honest, she's already been found not competent and we're in the competency restoration phase. I don't really see that there's much of a purpose for advocate counsel at this point, and I could tell you if she were restored to competency, the first thing she would do is fire me. I don't think I'm serving much of a purpose here. I would just ask to withdraw. If she's ever found competent and wants me back, I'll happily be reappointed, but I'm not doing much in this case.
All right, then I will permit your withdrawal on the record with the understanding that if needed in the future, we'll be approached. We can go that route. Okay. All right, so that's where we are. I don't know. Perhaps we should set just a status in this. Maybe 9 o'clock on November 4th, just to figure out where we're going, if anything's transpired, if we haven't received anything further from DHS.
9 o'clock.
9 o'clock, November 4th. All right. There we go. So, Mr. Chapman, can you come up and get her notice?
I will.
Thank you. Then we are free to leave. our. Where'd Captain go? Oh, thank you, thank you.
I apologize. I don't know why. I don't-
And just like that, case closed. Imagine filing a motion, requesting a hearing, and then not even showing up. Automatic dismissal. A brutal but simple truth of court. If you don't show, you don't win.